Hello, welcome to today's live. So what are we going to talk about today? Okay, well, the Biden executive order, which DHS has now termed Keeping Families Together, is going live August 19th. So I thought I would talk about that for a little bit before I start answering questions. You're free to ask whatever questions you want. I will scroll back and get to your questions right after I'm done doing my little spiel on the Biden executive order. So, what exactly is it? Okay, what did he do? Okay, well, keeping in mind that today is the 19th, which means today it goes live for the first day. Okay, and without even knowing the specifics, if you're married to a U.S. citizen and you don't have legal status, and either two things, you don't know what to do, or you would have to leave the country because of and do a provisional waiver and all kinds of issues with that, then this program is for you. So, Biden, what he wanted to do, what President Biden wanted to do was have comprehensive immigration reform, and that just didn't happen. Okay, there was not agreement, they couldn't get together, so that just wasn't happening. So what he did was issue an executive order that essentially allowed people who were married to U.S. citizens to file for this, what's called parole in place, in order to obtain legal status and get the green card. And it applies to a few different situations, okay? So even if you have another path you're going at right now, which may take years, may be denied, whatever, it's no problem getting this particular program and going forward and preparing the application. Okay, it's like I always say to my clients who ask, it's like two horses going around the track. The first one to the finish line wins. So if in fact you qualify for this, but you already have some other application going forward, that's okay. Okay, go forward with this. And let me explain. Let's say that you're doing the regular consulate processing. You're married to a U.S. citizen, but you're here legally. You can't adjust, and you're going to have to do what's called the provisional waiver of inadmissibility. That, of course, takes a long time. But once, hopefully, that gets approved, you leave the U.S., and then if everything goes smoothly, you're only out for 2 or 3 weeks, and then you come back, and you're a lawful permanent resident. Okay, I have lots of clients that are like that are in the middle of the process. If you ask anybody, they would prefer to do the process here without leaving if they could, not leave the U.S. I mean, the fact that it's called a provisional waiver should tell you. That means if you leave the U.S. and the officer sees that there's another ground of inadmissibility other than the 3 to 10 year bar, well, that means that the provisional waiver goes into effect and the officer says revoked. Okay, and then who knows how long you're going to be out. So it's always better to pick and adjust in the U.S. if you can, because the reality is if something goes wrong, well, you're here. Okay, you can appeal, whatever. If something goes wrong and you're outside the U.S., well, it's a whole different story. Okay. You're going to be on pins and needles waiting to come back in, and nothing goes fast at immigration. So, in the case, for example, where the client is doing that consulate processing and that provisional waiver, I have said to them, look, you qualify now to do the Biden executive order. We file everything. It can actually be filed online, although sometimes I prefer to file in person, or not in person, but to mail, because to make a complete application, a lot of times the online filing doesn't allow that. And obviously we want to make sure that there's the best chance of success. So if it has to be mailed with all of the attachments and so forth, that's the way it is. So I tell them, okay, we prepare this, we file it, but we do not withdraw the consulate processing right now. Okay, never withdraw it unless you're sure you don't need it. Because just in case something happens with the Biden executive order, who knows? Maybe some litigation will occur. Maybe some new regulations will come out and say you can't do this and you can't do that. That usually happens when these new programs come out. It's real nice at the beginning until, all the issues come out. But what happens is we file here. Hopefully everything goes through. The parole in place is approved. And then you end up getting your green card. And the moment you have your green card, you can withdraw the application at the consulate. Don't have to worry about the provisional waiver. You can say, thank you very much, but I have taken another route. I am withdrawing my application. Goodbye. Okay, so that's that. So let's get into some of the specifics of what is needed in order to qualify. Because that's the next question you all have, right? What do you need to qualify for this new executive order? Okay, so first, you have to be inside the United States without permission and not under parole, okay? Which is kind of strange. The first requirement is that, for all intents and purposes, you have to be here illegally, okay? That's the first requirement. Second, and this is what's going to catch a lot of people, because a lot of people think everybody qualifies for this, but that's not true. You have to have been in the U.S. physically present since June 17th, 2014. Okay? June 17th, 2014. So what does that mean? For all intents and purposes, that means you've been here for 10 years. If you haven't been here for 10 years, then you don't qualify, okay? And even if you've been here for 9 years and a year from now is going to be 10 years, you still don't qualify. That date is fixed, okay? There's no way to argue around that. There's no way to bring litigation. That is fixed, okay? It's June 17th, 2014. If you came after that date, well, then you need to go another route, okay? And usually I can find other routes for people to take, okay? But that's a key. You have to have been legally married, okay, to a U.S. citizen before June 17th, 2024, okay? So as long as you were married before June 17th, 2024, then you can go. Now, a lot of people are going to say, well, my spouse is a lawful permanent resident, not a U.S. citizen, so I don't qualify. Okay, well, there's nothing in these requirements that say that lawful permanent resident cannot naturalize and become a U.S. citizen. So if you meet the qualifications and the lawful permanent resident naturalizes and becomes a U.S. citizen, then you're going to qualify. Okay, so that's that. And then the next one is that you have no disqualifying criminal history. And this is the key, okay? Not deemed to be a threat to public safety, national security, or border security. So the question is, what does that mean? And that's great, okay? It's a gray area. That's very gray. This is where the litigation is going to come. Because it doesn't specifically list anything other than, a threat to public safety, national security, and border security. So as a lawyer, we would argue that regardless of what crime you have, assuming it's, not a really bad one, that you qualify for this. And it's not like you need a waiver. You don't need a waiver of inadmissibility for the crime. And that's great, right? You go under other areas and you do need a waiver, but for this particular one, there's no waiver. You just need to show that, in fact, it's not a threat to public safety, national security, or border security. So obviously, the more severe the crime, the more arguments are going to be needed in order to show you don't fall under that category. And there's all kinds of ways of arguing that with the legal brief, declarations, affidavits, all kinds of stuff, even possibly going to a psychiatrist or psychologist for a report to show that you are not a public threat, and whatever happened because of whatever reason, and that's over. Okay, so there's all kinds of ways of showing it. So this is unique in that you can still have crimes, but you don't need a waiver, and you can still qualify and get the green card. Okay, so that's that. That's the bottom line. That's it. Okay, so hopefully that was clear. But that's the bottom line. So the doors are open. So if you qualify, don't sit and do nothing. If you have other stuff going, do it. Okay, go forward. All right. So let's go do some questions now. So I'll just scroll back. Let me see. Okay, just take a second. I wish there was a way I could just press a button and all of the questions would just magically go up here, but it doesn't happen. Okay, just a minute. Okay, my case is, and I'm not at the beginning yet, but here's one. My case is in the BIA, and I am divorced. Can I marry a U.S. citizen? Okay, well, I don't know why your case is in the BIA. Okay, that's the Board of Immigration Appeals. I don't know if it has anything to do with a marriage petition, or if it has to do with asylum or removal, or you were denied cancellation. There's all kinds of reasons it could be in the BIA. But there's nothing stopping you, if you're divorced, from marrying a U.S. citizen. Okay, now you have to keep in mind that when you marry a U.S. citizen and you are in removal proceedings, so the question now is whether you are actually in removal proceedings because it's at the BIA. But assuming they deem you are, then you have a higher burden of proof to prove that the marriage is bona fide. Okay? Meaning that they think the only reason you want to marry a U.S. citizen now is because your case is at the BIA, you're in removal proceedings, you don't want to be deported, and you think this is going to help you. However, if you really love the person and you can show that it is a normal relationship, then yes, you can do it. Now, the question becomes after, what can you do to resolve your status? And I can't answer that without knowing why your case is in the BIA and several other things, but at least you can get married. You don't have to worry about that. Okay, let's see. Okay, let me scroll down now. Thanks for your patience while I scroll. Just a minute. Okay, let me get to the next question. I'm almost there. Okay. Oh, here's something from TikTok. It says, encourage your viewers to share your live and invite more friends. Okay. Share my live and invite more friends. Okay. Just a minute. Okay. I got a question for you. Okay. This guy has a question for me, but he didn't put what the question was. So this is Crinkle Tooth McManison. If you have the question, go ahead and put it there. I'll answer it. Do they do medical and physical for the PIP? That's a good question. Okay. The process is twofold. Okay. The PIP, the parole in place, is just to get you approved. Okay. Where it kind of creates a legal fiction that now you're here legally because you've been granted parole in place. Now, assuming you have, then you have to, afterwards, you have to file the regular adjustments. Okay. You don't file the PIP and then it's approved and then get the green card. It doesn't work like that. You file the PIP, it gets approved, then you file the adjustment. And of course, when you file the adjustment, of course you have to do the physical. So nothing changes in regards to that. Okay. Let's see. And given that I said that, where I said you don't need a waiver, you don't need a waiver to get the PIP approved. Okay, that's for sure. But if you do have criminal history, you're likely going to still need the waiver, the criminal waiver with the adjustment application that will be filed after the PIP is approved. Okay, so it's not perfect, but it's good. All right. Okay, my husband was deported in 2000 on a DV case, that's domestic violence, but he had a clean record since. Does he qualify? Okay. So first of all, you say he was deported in 2000. Was he deported but he stayed here? Or was he deported but he left? Okay. Obviously, if he's out of the country and he hasn't been physically inside the country since 2014, then for sure he's not going to qualify. Okay, for sure. But let's assume that he was deported and somehow he's back in the country. Okay, I'd have to know, did he enter illegally? That would mean, does he have an illegal reentry? If so, that means under normal circumstances, he is inadmissible permanently because of an illegal reentry after a deportation. However, under PIP, there is nothing here. I mean, as I read here, there is nothing here that specifically says you cannot have been deported, you cannot have illegally entered. Okay, nothing that says that. So again, this is where all the litigation is going to come, because lawyers like me are going to look at these requirements. So there's nothing that says you can't do that, and we're going to do it, and we're going to file it, and eventually, the other side's going to go, wait a minute, you can't do all that with, a prior deportation, and then litigation will begin, and then it'll, eventually it may say you can't do it. But right now, I would do it. Okay, I'd need to know why, what the sentence was on the DV. Okay, if it was more than a year, then he's an aggravated felon. But even then, as an aggravated felon, that's not a bar to the PIP either. Okay, it's obviously more difficult to prove that it's not an issue of public safety and so forth. But obviously, since you're asking the question, and I'm assuming the domestic violence was committed against you, hopefully things have been resolved and he can show rehabilitation. Okay, so still lots of questions that I would need to know, but it could be doable. Okay, all right, let's see what else we have. Just a minute. I'm just scrolling. Whoop! Oh man, it just went all the way up. Just a minute. Okay. Well, she answered me back. He was sent back and re-entered in 2003. Okay, which I thought. See, I knew that happened. And so because of that, he's obviously been here all the years. So he's got a prior deportation, he's got an illegal re-entry, and he's got a domestic violence. So he's got a hard case. But there's nothing that I see that he can't do it. Okay, and this might be the only realistic way he does it, because he can't do it normally. Okay, he can't do a normal adjustment. Obviously, if that was the case, then he'd already have his green card right now. So contact my office. I'll let you know what's involved, because it is possible. Just a minute. I scrolled past a bunch of questions. Sorry. Okay. What is the permanent bar, and do you qualify for PIP? Okay, well, the permanent bar is issued in a few different ways. Okay, but for all intents purposes, the permanent bar is when you're deported, or even if you're not deported, when you enter illegally and then you enter illegally again. Okay, for all intents purposes, that's what it means. You've entered illegally twice. That's a permanent bar. There's nothing in there that says you can't do it if you're subject to the permanent bar. Okay, that's what's great about when these programs begin. And that's why I advocate that you need to get it out the door quickly, okay? Because I know from practicing for 30 years that litigation is going to go up and down on this like you would not believe. I know it's going to happen. But it's not going to happen for some time. And if you can do it now, okay, if you can get it prepared and filed now, then they being the adjudicator has nothing there to say what you cannot, regulation blah 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 says you can't do it if you have a prior deportation or a permanent bar. Okay, so we make the arguments, we go forward, and then hopefully it would be approved. So I need to know other stuff to know if there's qualification, but at least at a minimum, there's nothing that says that that's a bar, okay, to filing this. All right, just a minute. I am scrolling again to get to the next question. Okay. From Cabrona. Husband has been here 28 years. Now he's in immigration detention for the past 7 months, and we have 6 United. I assume you're saying you probably have 6 United States citizen children. Okay. I'd need to know why he's in detention. Let's see, just a minute. You have another follow up here. Is he allowable to get PIP if in detention? Okay. Again, I need to know why he's in detention. What crime does he have? Okay, I assume he's in detention because he committed some crime. Did he plead guilty to it? What was it? Is he an aggravated felon? But again, there's nothing here that says you cannot apply for this if you're in detention. Okay, nothing. I would make the argument that he does qualify, that he's been here. I mean, I assume he's been here obviously he's been here for at least the 10 years, and I assume that you're a U.S. citizen and you're married. The crime, whatever he's in there for, we need to argue it doesn't affect public safety, national security, or border security, okay? Obviously, we're going to argue that up and down because the other side, whatever it is going to argue, and that being immigration, is going to argue that he is a threat to public safety. So, it's not just a matter of, saying this person is not a threat to public safety, national security, or border security. Okay, that's not how it works. We have to make a very coherent argument. And we have to attach lots of exhibits. We have to show rehabilitation. We have to show all the facts of why the crime occurred in the first place. We have to show that this person has turned out to be a good person. Maybe this particular thing was bad. We need to get an evaluation from a psychologist that it's not a public safety issue. Okay, so there's all kinds of stuff that we need to show. But I would argue that he is eligible, and it's a matter of going forward. Okay. So if you have a felony PC-32, would you be eligible? I don't have all the statutory code sections memorized, and I don't even know if you're talking about in California or some other state. Okay, so I don't know. So if you can, write back and tell me what PC-32 is. Okay, is it burglary? Is it robbery? Okay. All right, so let's see. This is the same question here, so I don't know what PC-32 is. I need clarification. Okay, and again, the one you were married in 2005. So again, you meet all the qualifications for the PIP, but we have to add the extra layer of argument that he still qualifies with all these things, and we can say the law is very specific. It doesn't put what that illegal reentry or deportation makes you ineligible, and you still should be able to go forward. Okay. If I just got the 601 waiver approved last month, can I apply? What evidence do I need to provide? Well, this is what I was talking about in the beginning. Okay, 601A is the provisional waiver. This means that you are unlawfully present and that you're going to go to the consulate at some point in the future, and if they find anything else that you're inadmissible on, they are going to say provisional waiver revoked, and then you're going to be stuck outside. The answer, if you qualify, assuming you qualify, the answer is yes, file for it right away. And there's all kinds of evidence you need, okay? So just call my office, all right? I'll let you know what it'll take. But you should definitely do this instead of going out, because you never know what's going to happen. And I guarantee you would prefer to do it here than go out, regardless if you got the 601A approved. I mean, you do know it says provisional waiver, and provisional means if anything else shows up, they're going to revoke it, okay? All right, so it was a misdemeanor. All I did was touch it. Just a minute. Okay. Wait. Okay. Went to a lawyer. He said it was a waste of time to apply with a permanent bar. How would that lawyer know? The program started today. The regulations are out today. The requirements are here. How does the lawyer know that it is a waste of time to apply with a permanent bar? There is nothing on there that says that you can't do that. Okay. Did you go to an immigration lawyer? One that was experienced? I mean, honestly, you can't just sit back and let it go. You have a permanent bar and you have an opportunity now. I'm not saying that it'll be approved for sure, obviously. Nobody can guarantee that. But if you have a shot at the apple, you got to take it. Okay? So get someone who knows what they're doing and argue it. Okay? So domestic violence misdemeanor. Again, domestic violence misdemeanor, that obviously is not good, but you can certainly argue not a threat to public safety and so forth. I don't know if that person maybe went to some classes. Maybe maybe he's an alcoholic and went to AA and is all better now. I mean, there's all kinds of ways of arguing it. Okay. Another lawyer said, see, we're getting into what the other lawyer said. One DUI misdemeanor will put you in deportation proceedings if you apply for PIP. Okay. I can pretty much tell you that lawyer probably has never done a deportation proceeding. Okay. I mean, you understand if that was the case, you could be put in deportation proceedings tomorrow. Okay. And you have a DUI misdemeanor, which even if the PIP didn't exist, okay, if it didn't exist and I was doing the adjustment for you, there are waivers and ways of arguing. I do it all the time with people who have DUIs. And if you can argue it regularly, you can certainly argue it with the PIP. Okay? So don't take what, these statements as fact. Okay? A lawyer sitting there saying, you will be put into deportation proceedings if you apply. How does that person know that? Okay? Did the person analyze your DUI and see if that even makes you inadmissible? And if so, under what sections? Okay? Can't just pull stuff out of the air and say that. Okay? All right. Denied cancellation of removal. We were talking about this way up. Just a minute. Okay, this is a different one, but it's the same question. Okay, I have a 601A with a BIA and with the visa and have been married 10 years. Can I apply for PIP? If you again, it's a little different in that I assume you're at the BIA. You've appealed the case. Okay, but assuming you qualify, yes, you should go forward. Okay, I mean the bottom line is, if you have the opportunity to do it here, do it. And if after everything's argued and all said and done and it gets denied, well, you still have the 6OA. You still can go out and consulate process. Okay? That's the way it is. If my husband left after 17 years, now has a 10-year bar. Well, I mean, if he's not in the country, for sure he's not going to qualify. Okay? He has to be here, and he has to have been here for the last 10 years. Okay. I need to know if he's here. Did he enter again, as with the other one? Did he enter illegally again? Has he been here for the 10 years? Okay. So you clarified California PC 32 as accessory after the fact, but I need to know accessory after the fact of what? Okay. Accessory to what? And what was the sentence? Okay. But that by itself, again, without knowing more, that by itself, I could certainly argue shouldn't fall under the public safety and all that. But again, I need to know specifically what the underlying crime was of which you were an accessory after the fact to. Okay, that makes an issue. Okay. Let's see. Married to U.S. citizen, been here for 10 years. Well, that by itself tells me, at least on the face of it, you qualify and you should go for it. Okay? Well, where are you from? Well, my office is in Long Beach, California, but I help people all over the U.S. Okay? Immigration law is federal law, which means I am able to help everybody, and my office is completely electronic. I mean, we create a web portal, you can submit all the documents there, and so forth. Okay, so it's great. All right, well, that is my Parole in Place Live. Hope you all enjoyed it. Now I have to get back to work. So everybody have a good day. If you have further questions, you can contact me through the regular channels, and I can have my office set up a consultation for you. Okay? Everybody have a good day.